both the houses, my lord, respectively on 28th June and 1st July, my lord, approved the extension of the President's rule. Now comes, my lord, an important event. Again, my lord, to ensure that those who are staying in border areas are having a sense of security, social security. 1st July 2019. It is critical to note that on the same day, Jammu and Kashmir Reservation Amendment Act was passed by the Parliament, exercising powers as the legislature of Jammu and Kashmir. Your Lordships have seen Article 256 1B, that when President's rule is there, the Parliament exercises the powers of the legislature. This enactment was passed. Considering the strategic and security concerns in mind, the Jammu and Kashmir Reservation Amendment Act was passed by the Indian Parliament. This fact is mentioned to show that, like in past, the Parliament has exercised legislative powers of Jammu and Kashmir Assembly under Article 356 1B. Prior to, this is important, prior to the aforesaid Act, some category of reservation was available only to border areas of Kashmir Division. Border areas of all divisions, that is Kashmir, Jammu, were facing frequent attacks and shelling, and resultantly more hardship regimes prior to 1/3/2019 somehow confined the reservation benefit to borders areas of Kashmir Division only. Look, there are several steps which are required to be taken in view of several circumstances which the nation faces. And these are the steps as precursor. Lord, kindly see now PDF page 229 of this very compilation. Lord, I have said that this has been the practice and a constitutional convention throughout. Whenever there is a President's rule, the Parliament exercises the power of the legislature as contemplated under Article 356 1B. In all states, yes. Lord, page 229. I'm not reading, but I have taken, my lord, till date, whichever are the acts passed by the Parliament, acting as a legislature of the state during President's rule, the list is given, my lord. But there are total 248 such laws passed. Just go to 242. I'm sorry, 243. There is something which would require your Lordship's attention. 242. I'm sorry. At 243. This is, I'm showing in case of Punjab. The most important part of any legislative transaction is passing of the budget. Budgets are passed by the Parliament on behalf of the states, acting as a state legislature. Come to, my lord, the important part, 243, and I'll point out, my lord, what is the relevance of showing this. In case of Punjab, your lordships would find item number 31, the Punjab Reorganization Bill. Your lordship gets that? Yes. My lord Justice, 240. But during the President's rule, the Parliament acting as the legislature even reorganized the state of Punjab. Something which happened here, my lord. Lord, Punjab was divided, bifurcated into Punjab and Haryana. Chandigarh was carved out as union territory, and some part of erstwhile Punjab went in Himachal. These were the four bifurcations, my lord, which took place by Punjab Reorganization Act passed by the Parliament acting as a legislature. So, my lord, it is not uncommon, or it is not something which has happened for the first time, that you can elevate the argument to the level of a constitutional fraud.
But this must be a Reorganization Act under Article 3.
Yes, I'll come to that, my lord. I'm coming to, because I'm right now, my lord, pointing out that suspension of proviso to Article 3 is not unusual. Whenever provision is suspended and precedent rule is also imposed, the parliament acts as a legislature. My lord, and this, my lord, make my submissions on reorganization act, I'll, my lord, also point out this reorganization act was challenged on this very ground before Delhi High Court.
Yes, Punjab,
Yes, my lord,
Punjab,
Punjab
Haryana.
judgment. My Lord Justice H.R. Khanna's judgment. And it was also challenged before this honorable court and Mangal Singh, I'll point out, 5-judge bench judgment. This very reorganization act. Now coming back, my lord, I'm sorry.
Yes.
Lord, kindly come to 10. Lord, before I take, my lord, now, my lord, I am on the last leg of this written submissions, my lord, namely,
But Mr. Solicitor, if the powers of the legislature of the state under 356B can be exercised by Parliament, then what is the constitutional necessity of suspending the proviso to Article 3?
so that legislature, if present, if not dissolved, may not do anything. But this is, we are dealing with a case where the legislature was dissolved. But suppose it is in suspended animation. The legislation remains, the legislature remains. It might assemble and pass a resolution.
To be very frank, except in the case, possibly the case of Punjab, I don't think Article 3 would have been invoked in many other cases. But as a matter of convention, what has been happening is whenever 356 is imposed, going by your submissions, proviso to Article 3 is also suspended.
Suspended.
Because the power under Article 3 is different from the power of legislation.
Correct. No, my lord, my lord, point out 356, my lord, kindly just taking a
That's
little
what was
detour.
highlighted was power under Article 3 is different from the power of, which is conferred of making legislation, making or enacting laws.
That's where, my lord, I would like to say something if your lordship takes 356. Taking a slight detour, my lord.
No, it says to calls about functions.
It says the powers of the legislature.
Powers.
No, not just powers to make laws.
Correct, it's broader, it's
All
broader.
powers.
All powers, and now please see proviso to subarticle, to Article 3. Proviso to Article 3. Provided that, I'm sorry, sir. Yes, sir. Provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President and unless where the proposal contained in the bill affects the area, boundaries or name of any of the states, the bill has been referred by the President to the legislature of that state for expressing its views thereon. This is the different power of the legislature than power to make laws. So even this power in the present case was exercised by the parliament. Now, my lord, before I take, my lord, the last leg of my.
Otherwise, in the absence of the suspension of the proviso, what would happen was that the Parliament is exercising all the powers of the legislature of the state. It would give its views on it, and it would also enact the bill.
Yes, ma'am. Yes, ma'am. That's the constitution.
So that's your answer to the challenge that there's duality is missing in this case, because you say when Article 356 is invoked and we have been and the proviso is suspended, there are instances in the past wherein it was this argument of duality was rejected.
Yes, ma'am. My lord, I can, my lord, take directly your lordships to.
Or we'll come to that. You go in your own way.
No, otherwise, my lord, Justice H.R. Khanna's judgment on this as a Delhi High Court, my lord, in Delhi High Court is directly on the point. And explanation and my lord, the interpretation of Article 3 by a constitution bench in Mangal Singh. That also, my lord, concerned Punjab. This very reorganization, which was under 356 and the power exercised by Parliament as a legislature. But in Punjab, incidentally, even views were not taken of the Parliament. as a legislature, saying that the assembly is suspended. So straightway, the reorganization bill was passed. As a reorganization, Manoj, this is interesting, and I'll show that judgment. What happened was, in the erstwhile state of Punjab, Manoj, for example, there were 85 seats of MLAs. Now some portion goes, so 85 became 70. The remaining 15 challenged them. That how have you taken away our right to continue as members of the Legislative Assembly? And the number was lower than even minimum prescribed for any assembly to have. And then the question arose about Article 4, that you can make incidental provisions which might even amount to amending the Constitution but would not be treated as amendment of the Constitution. Constitution bench of your lordship. But since, my lord, we are on this, let me, my lord, show Justice H.R. Khanna's judgment, my lord, because your lordships have just seen Article 356 and Article 3. My lord, kindly have a look at, my lord, Volume 1, see, my lord, compilation Volume 1. That is a separate argument, but at this stage, my lord, I'll just show these two judgments, my lord, just to. It's marked, my lord, in my written submission also. It's easier, but rather than going to page 167 of this very compilation, a very
Now you are back to the original one.
written, yes, ma'am. So that, my lord, your lordship may not have to shuffle through. Yes. Lord, what I have done is, for your lordship's convenience, I have quoted the para of my written submissions, my lord. That is joint written submissions, volume 3.
67, right?
167, my lord. On reading Article 3 and Article 174(1) of the Constitution, along with above proclamation of the President, it is seen that the President had suspended the power of Governor to summon the House or each House of Legislature of the state, which by itself prevented the state legislature from meeting, and also suspended the state legislature from meeting, and also suspended so much of proviso to Article 3 of the Constitution relating to the reference by the President to the legislature of the state. It will thus be seen that the power to summon the legislature of the governor having been suspended, no occasion could thereafter arise during the period when such suspension was in operation for the legislature to meet for the purpose of expressing its views on the bill. Here it was dissolved. The bill to be introduced in Parliament affecting the area, boundaries, or name of the concerned state. This would be the direct result of the suspension of the power of governor to summon the legislature of the state, even without suspension of so much of the proviso to Article 3 relating to the reference by President to the legislature of the state. However, in order to make the matter clearer, the operation of so much of proviso to Article 3 had also been suspended by the President. In view of the clear power conferred by Article 356(1)(a)(b) to declare that powers of the legislature of the state shall be exercisable by or under the authority of Parliament, it enacted Act number 31 of 66, by which all powers of the legislature of the concerned state, state of Punjab, to make laws were conferred on the President. We can find no warrant for the contention of the petitioner that what was transferred by means of Article 356(1)(b) of the Constitution was only the legislative power of the state legislature, but not the power to meet and express its views as contemplated by the proviso to Article 3 of the Constitution. But as my lords pointed out, that the word power is wider, which includes power to make law, but all powers, give recommendation, expressing views, etc. 3 of the Constitution. According to the petitioner, Article 356(1)(c) only enabled the President to make such incidental and consequential provisions as appeared to him to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operation of any provisions of the Constitution to any body or authority in the state, but not to make provisions which were not both incidental and consequential. This was one of the contention. This argument of the petitioner would appear to have no validity for two reasons. Firstly, the expression incidental and consequential may be read as incidental or consequential to suit the context that this is a permissible mode of construction if the context so requires. It is well settled. It will be sufficient to refer. Then the judgment is when N can be read as or your lordships may skip. Para 10.
Mr. Solicitor, you have referred to the fact that there's a practice, a constitutional practice that during the operation of a proclamation under 356, the proviso to Article 3 has been suspended. And you have said that that is obviated by the reason that if you don't do so, and the legislature is only in a state of suspended animation and not dissolved, the legislature may conceivably meet to express its view. To obviate that, Parliament, the presidential proclamation does this. But none of this constitutional practice cannot obviate the legality of what is done, right?
Here, in the present case, even the views are taken, but views are given by the Parliament as a legislation. In Punjab, that was not the case.
So Parliament would then give the views
To itself.
and it would also enact the legislation for reorganization.
Yes, but that's the inevitable consequence.
But would that really be consistent with the federal
I will
document?
show that. I will show that. It does not destroy federalism at all. I'll be able to satisfy your lordships. I'm just, since we are discussing this, I have not taken up the point of state reorganization.
All right, but you're saying that
Yes, but since we were answering, I was answering the proviso to Article 3, which came with 356, I'm reading this.
all right.
Para 10, it can hardly be denied that the dispensing with the need to consult the views of concerned state legislature was itself a direct consequence of the legislature being unable to meet for any purpose whatsoever during the period when governor's power to summon the legislature was itself suspended. The petitioner does not advance his case in any manner, therefore by laying stress on the expression incidental alone in Article 356 1C. Secondly, the petitioner cannot seek to derive any assistance from the English decisions which he quoted in order to show that what he contended was the restricted meaning given to the said expression, etc., etc.